This is Bloomberg Law with June Grasso from Bloomberg Radio.
It's a landmark legal doctrine that affects agency power over everything from workplace conditions and drug safety to climate change and cryptocurrency. The Chevron doctrine requires judges to defer to agencies when they offer a reasonable interpretation of an ambiguous statute. And the challenge to the 40-year-old doctrine puts regulations in countless areas at risk. Billions of dollars are potentially at stake in front of a court where 4 of its conservative members, including Justice Neil Gorsuch, have previously signaled opposition to Chevron, as they did during the oral arguments.
Is the judge persuaded at the end of the day, with proper deference given to a co-equal branch of government, or does the judge abdicate that responsibility and say automatically whatever the agency says wins?
On the other hand, the 3 liberal justices supported Chevron and the expertise of agencies. Here's Justice Ketanji Brown Jackson.
I see Chevron as doing the very important work of helping courts stay away from policy making.
The decision may depend on Chief Justice John Roberts and Justice Amy Coney Barrett, with Barrett repeatedly voicing concerns about a possible legal upheaval if Chevron is reversed, alluding to the more than 15,000 cases that have cited the doctrine.
So maybe nothing happens immediately to those cases, but isn't the door then open for litigants to come back and say, well, stationary source really means X, or, broadband or whatever the specific term was in Brand X. So isn't it inviting a flood of litigation, even if for the moment those holdings stay intact?
Joining me is constitutional law expert Harold Krent, a professor at the Chicago-Kent College of Law. The Chevron doctrine, by the way, championed by conservatives when it was established in a case that cut back on regulations, but now vilified by them. It's become a pillar of administrative law. Tell us how it's used in practice, what the practical application is.
The practical application of Chevron is enormous. It allows a structured way for courts to determine whether to uphold agency interpretations of statutes, whether it's in rulemaking or in a case in adjudication. And so if the statute is vague, let's say a reasonable size for a truck, or in the famous case of Chevron itself, what's a stationary source, a court will have to decide whether Congress has been clear. And if Congress has been clear, that's the end of the matter, and the court's interpretation will hold. The agency can appeal it if it disagrees up to the Supreme Court. But in many cases, the courts are left with doubt. I mean, what is a reasonable investigation? What is an adequate measure? And they're not certain how to interpret it. And so then the court will defer to any kind of reasonable agency interpretation. Reasonableness is in the eye of the beholder. That means that there's an array of possible interpretations for one statute, and they all would be upheld by a court on review as long as it's ambiguous and as long as the agency's interpretation has some degree of plausibility. That, of course, gives agencies more power, and it gives agencies the ability to change their interpretation of regulations as social or political conditions evolve. And that has enormous significance both for business and for individuals regulated by the government.
Many of the conservative justices have expressed opposition to Chevron. Why are they so opposed to Chevron?
Justices are opposed, I think, for 2 different reasons. The first is, in all other contexts, judges make the final call as to what Congress meant in passing statutes. So if there's ambiguity, courts have the final say. That's what courts do, and courts think that they're better at it, and that's their special function. So under Chevron, the courts have to share this special function with agencies who they view as sort of unelected bureaucrats or politicians. So that's an affront to judicial respect. I think that's one argument. The other argument or reason is that this particular court is very skeptical of administrative agencies and administrative agencies' power. They love presidential power, but they don't like the power of the bureaucrats beneath him. And there's no question but that agencies under both Republican and Democratic administration have more authority and more influence if the Chevron doctrine is applied accurately.
Members of the conservative majority, several members of it, immediately made their concerns known. Justice Neil Gorsuch questioned why a judge who thinks the agency's interpretation of the law is wrong would, quote, abdicate that responsibility and say automatically whatever the agency says wins. Did certain of the justices express real opposition?
Yeah, it's clear that a supermajority of the court is very worried about, uncomfortable with Chevron, but it's not clear whether there is a majority of justices who want to overturn Chevron outright as opposed to continue what they've done before, which is to weaken Chevron for lower courts. And as the justices themselves noted at several times during the oral argument, the Supreme Court has not itself relied upon Chevron for something like 7 years in deciding a case, which means that they're sort of ignoring it because they just try to decide what a statute means itself without formally using the Chevron framework. And so the question is whether they can allow Chevron to die a slow death, or at least to be left in a weakened state, or whether instead the conservative justices will decide to overturn Chevron outright. And as was definitely remarked upon in oral argument, that would cause a great deal of instability, because the question would then be, what about all these cases that have been decided in reliance upon Chevron? Does that mean that they will have to be reopened to determine whether the courts want to rethink what is the correct interpretation to give to the statute that was challenged?
The liberal justices defended Chevron and the status quo. Justice Ketanji Brown Jackson said Chevron helps courts stay away from policymaking. Justice Elena Kagan gave some practical examples, like should courts defer to an agency's expertise as to whether a cholesterol-lowering product should be classified as a dietary supplement or a drug? So, I mean, those arguments seem to make sense when you consider, on the ground level, what agencies are deciding.
Well, in addition to that, there's long been a debate about what Congress intends. There's been studies that suggest that Congress is comfortable with Chevron, understands Chevron, and indeed would want the agency to fill in statutory gaps or clarify statutory language as opposed to the court. Why? Because agencies are seen as Congress's partner in trying to look at safe drug policy, or try to understand immigration policy, or try to understand how to regulate the airwaves. So Congress indeed would prefer or intend for courts to help them interstitially by trying to clarify ambiguous language, as opposed to the court, which doesn't have the same kind of expertise, same kind of flexibility in trying to figure out what statutes mean. So viewed from that perspective, Chevron is indeed consistent with separation of powers once one comes to the conclusion that Congress would prefer to have the agencies flesh out statutory meaning if the statute's unclear, as opposed to the court, because the agency has the expertise and it works with Congress in trying to accomplish the congressionally delegated mission. Which is why conservative justices like Antonin Scalia used to applaud it, because it reflects Congress's intent that the two entities, Congress and the agencies, are really working together to accomplish a similar mission.
So the Solicitor General, Elizabeth Prelogar, argued that overruling a past Supreme Court decision requires, quote, a truly extraordinary justification, and petitioners don't have one. But does it really require a truly extraordinary justification for this court to overturn precedent?
There was discussion during the oral argument about what type of precedent Chevron was. It's different than the substantive due process question that arose in the Dobbs case. That's the interpretive approach. The analogy was made to, if you don't rely upon legislative history in the same way in one case as opposed to another, yes, it's overturning a case, but it's not really a stare decisis because individuals haven't relied upon it the same way over the past 50 years. But I think Congress has legislated in the wake or in the shadow of Chevron, and so it would be undermining what Congress's intent has been in drafting statutes for the last 50 years. So I think that would be the real change if Chevron is jettisoned, as it looks like it'll at least be winnowed down, if not jettisoned completely.
Coming up next on the Bloomberg Law Show, I'll continue this conversation with Professor Harold Krent of the Chicago-Kent College of Law, and we'll look at the possible lineup of the justices in the case. I'm June Grasso, and you're listening to Bloomberg. I've been talking to Professor Harold Krent of Chicago-Kent College of Law about Supreme Court oral arguments today over a long-standing legal doctrine that gives federal agencies a wide berth to interpret unclear laws. Did it seem like there were four justices, Clarence Thomas, Neil Gorsuch, Brett Kavanaugh, and Samuel Alito, who were ready to completely jettison Chevron?
My guess would be that the four justices you mentioned, Alito, Thomas, Kavanaugh, and Gorsuch, were clearly opposed to Chevron and didn't want to have any kind of lasting legacy on the court at all with respect to that decision, whereas Justice Barrett and Chief Justice Roberts were more on the fence in terms of what kind of response the court should take. Should the court go all the way and overrule Chevron, or should they just limit Chevron even further than had been previously limited by the major questions doctrine? Indeed, many commentators think that because Chevron has been watered down, particularly with this major questions exception, that gives the court enough leeway to limit the kind of power that agencies would otherwise wield under Chevron.
Yeah, and Barrett expressed concerns about the disruptive consequences of overturning the precedent.
Yeah, so one of the things that that litigators don't remember today is what life was like before Chevron. And the problem that arises is when the agency makes an interpretation, it can be challenged in many different circuits around the country. And then oftentimes, different district court judges will interpret ambiguous statutory language differently. And so you have the prospect, and you will have the prospect again if Chevron is overturned, of having a disarray, 7 different or 3 different interpretations of one statute that are enforced in different circuits. And that makes planning and makes even stability for businesses very difficult. That's the kind of cacophony that was discussed in oral argument. And I think it's very real. It happened before Chevron. And one of the advantages with Chevron was trying to get a uniformity of approach to limit the splits among the circuits and the delay in trying to get stability of an interpretation, approved.
And just noting that in these cases, both the D.C. Circuit and the First Circuit sided with the federal government, affirming lower court decisions. So this wasn't a case where the justices had to take it. It was a case where 4 of the justices, and I think we probably know which 4, took it to change things up, right?
I think so. And what's intriguing about the case, too, is this was a policy that was adopted by the Trump administration and defended by the Biden administration, which suggests that it's a good vehicle for Chevron because it's not a case that looks more Republican or looks more Democratic. This just looks governmental. And justices did have an interesting comment that, just like if we get rid of Chevron, businesses will be advantaged, but at the same time, so may immigrants, veterans, and Social Security claimants, because all those individuals who litigated against the government have the burden of trying to persuade a court that the statutory language has been interpreted incorrectly by the agency. But they can do that more readily if Chevron doesn't exist, because otherwise they have to overcome the presumption that the agency's interpretation is correct in case of an interpretation of a vague statutory provision. And if Chevron were totally overturned, then at least theoretically, and it would be true in some cases, that individuals would have more advantage in litigating against the government. But of course, at the same time, so will businesses.
I remember one oral argument last term. The Chief Justice took account of the fact that, they're always saying this is something for Congress, but that Congress is gridlocked.
The comment that was made from both conservative and liberal justices was that ambiguity exists everywhere. It's impossible to get rid of ambiguity. And so there was no expectation that Congress would legislate with much more clarity. And indeed, if you overturn Chevron at the margin, it would give a little more incentive for Congress to minimize ambiguity, but they seem to be dubious that Congress would change very much at all. So it's not a question of the amount of legislation, rather it's a question of what kind of specificity would Congress legislate with.
These two cases, I'm wondering if there is any question about whether it's moot, because the program that they're complaining about was suspended last year, and the agency reimbursed the monitoring costs that had incurred under it. So why is this even before the court at this point?
The court in the past has taken a very narrow view of mootness, and as long as a law is in the books or could be put easily back on the books, it is considered it is reached out to answer those kinds of challenges. So my guess is this will be the same in this case, that the regulation has not been repealed. It could be reinstated, and therefore the controversy is still alive. But I will say that there's very little argument that I heard that would touched upon that issue whatsoever.
So if they decide to do something limiting Chevron, I mean, what would that look like?
They might say that Chevron can be used only when the expertise of an agency is clearly needed. Or they might say that a Chevron can be used only if the Congress has otherwise indicated that it intends for the agency to address the issue. So there was discussion at the oral argument today about whether or not one can slice and dice and get different kinds of contexts in which Chevron arises, as for, again, to sort of understand that Congress may have anticipated or may welcome agencies' interpretations more in some contexts than in others. If Congress is just silent, as in this case for the herring fishermen, that there was nothing in the statute about who pays for monitors on fishing vessels, in that kind of silence, there would be no reason to defer to the agency, but rather the agency should only get deference if there's more peculiar or more specific indicators that Congress intended the agencies to have some kind of interpretive role in administering a statute. That's when Chevron might be applied, not in a case where Congress seemingly just forgot about an issue, as in the who pays for the fishing monitors that was involved in this case.
Thanks so much, Hal. That's Professor Harold Krent of the Chicago-Kent College of Law. Coming up next on the Bloomberg Law Show, we'll take a look at a judge blocking the Jet Blue-Spirit deal on antitrust grounds. What happens next? A federal judge has blocked the $3.8 billion deal between Jet Blue Airways and Spirit Airlines over antitrust concerns. It leaves the two carriers adrift and means JetBlue will continue to be relegated to second-tier status behind the industry's big four carriers, which wield unmatched pricing power and command vastly bigger fleets. And for Spirit, the consequences may be dire. Joining me is Bloomberg Intelligence Senior Litigation Analyst Jennifer Rhee. Just how big a win is this for the Biden administration, which has been aggressive in antitrust enforcement?
You know, I guess I would classify it as a big win only because I think the administration needs wins on the M&A front, the M&A challenge front. But in terms of this specific case, I don't necessarily see it as surprising or a big win because this just seemed like an anti-competitive deal from the beginning, and it seemed like it should have been an easy case for the Department of Justice to win. So it's not a great feat, in other words, that they succeeded in court. But just generally, I think, in stopping any kind of consolidation and in kind of furthering the aggressive push to stop consolidation, to stop a lot of deals, in that way, it's a big win.
Tell us why the judge, William Young, decided against the merger of JetBlue and Spirit.
You know, I think what this really came down to is the fact that there are flights that Spirit flies where JetBlue doesn't. So it's odd because most deals will come down to where they compete, but I think this came down to where they do not compete because JetBlue was very clear about plans to take those Spirit flights, retrofit the planes to the JetBlue model, and probably therefore raise the fares and lower capacity because the seats would be bigger and there would be fewer passengers. And for those routes, there's no way from an antitrust perspective that you can fix those higher prices. You know, for routes where they compete, they could sell the route to Allegiant or to Frontier that might continue to compete as a very low, unbundled fare option. But now what you're doing is taking Spirit, which is considered an ultra-low-cost carrier and offers these very low unbundled fares. You're taking them out of the market for certain routes altogether. And there are absolutely consumers that depended on those low fares for those particular routes, and they would be hurt by this deal. And that's what the judge ultimately decided.
So that means that JetBlue will continue to be relegated to second-tier status behind the industry's four big carriers. And Samuel Engel of ICF told Bloomberg they don't have an easy path to grow. They'll continue to be, at scale, disadvantaged compared to the largest airlines. So this decision sort of relegates JetBlue, to a position it's in, or even worse.
I guess it does. And JetBlue argued, look, we need to combine with Spirit in order to grow. That's really the only way nowadays to grow as an airline. And if we grow, we can compete more vigorously against the legacy airlines like Delta, United, American, and Southwest. And that would be a good thing for consumers. That's pro-competitive. And the judge actually agreed with that in this case, that this would help JetBlue if it could combine with Spirit, help it to grow, increase its map, and better compete with some of the bigger airlines. But it wasn't enough. It wasn't enough to overcome the harm to the consumers that I just talked about. And I think that's why, in a way, yes, the decision does tend to relegate JetBlue to its position sort of as a second tier. But one of the things that happened here, June, that was pretty effective is that what the Department of Justice argued is that, look, in this kind of second tier place that JetBlue sits now, it's a kind of a maverick, right? It does something called the JetBlue effect. It really competes hard against the legacy airlines, and when it enters a route or the routes it's in, it forces these airlines to bring down their prices. And what they argued is, look, if they buy Spirit, they're telling you they'll better compete against the legacies. But in fact, they're really just going to become just like one of them. They're going to be bigger. They're going to be more in a position that's more similar to the legacy airlines. They're going to take on a huge amount of debt from buying Spirit, and they're going to need to keep their prices up. So instead of actually continuing to exert this competitive pressure, they just become like the legacies and they increase their prices.
The market appeared to like the news for JetBlue. JetBlue's stock rose almost 5% after the news. Is that, you think, because the company won't have to shell out billions of dollars and be saddled with a discount carrier?
I think so. I mean, first, it was a very large amount of debt they would have taken on to finish this acquisition. That's the first thing. Their debt ratio would have been much worse than it's been in the past. And they themselves aren't really doing all that well right now. All the airlines are struggling a little bit with air traffic controller shortages and airline shortages, and there's some engine problems for some planes, and, everybody's recovering after COVID. And then at the same time, what they're paying for Spirit now seems like an overpayment given what Spirit is worth today. So I think many analysts actually saw getting out of this deal as a good thing for JetBlue.
For Spirit, not so much. Its shares were cut in half Tuesday in their worst loss ever. And if Spirit doesn't survive, doesn't that mean the judge's analysis was wrong, or at least was not prescient?
Well, I think what happened here is that Spirit's lawyers could have made a more full-throated flailing firm or failing firm defense. Within the guidelines that the agencies use to assess a deal, there is a defense to an otherwise anti-competitive deal called a failing firm defense or a flailing firm defense. And it was sort of suggested in trial that Spirit's not doing well. They're struggling financially. They don't expect to make money next year. They don't know when they'll be in a better financial position going forward. And some of the issues they're having were outlined. And the judge said, look, they didn't really meet the elements they need to meet. Legal cases have set out the precedent, set out what has to be proven in order to establish that defense. And the companies just didn't do it. They didn't meet that defense. And that's why the judge rejected it. And I sat through most of the trial, and I tend to agree. I don't think that they provided the evidence they needed to provide that would have allowed the judge to say, okay, I'll let an otherwise anti-competitive deal go forward because of the fact that Spirit might actually go under if we don't allow the deal to close.
The judge wrote, the airlines are welcome to take another run at a merger at any time. The courthouse doors remain open should the defendant airlines decide to try again and the government then wishes to prevent such an attempt. Mm-hmm. Why say that?
Well, first, the DOJ asked for a permanent injunction that would prevent these two from ever trying to merge again, so they didn't quite get fully what they wanted. And it's exactly what's playing out in the marketplace now that this judge was worried about. I mean, he specifically asked during trial, well, what happens if there is no Spirit, if I don't allow this deal? What happens then? That's a worse situation. As he was sort of questioning the lawyers and thinking through the theories and sort of in a ruminating kind of way, he was asking that. And he wanted to leave the door open if marketplace dynamics did change, to allow these companies to try to merge again in the future. If, in fact, Spirit went belly up and couldn't be restructured out of bankruptcy, or some other suitor didn't step up, like maybe Frontier, to buy Spirit so that the Spirit routes would continue to exist. And he specifically wrote the injunction that way to allow for another deal possibly to go forward. But you know what, June, easier said than done, because these things are difficult. It's not just like you can jump into a merger agreement, get a DOJ investigation finished up, go to trial. It takes time. It hurts your business. It's expensive. And suffice it to say, it seems likely that if Frontier or, again, JetBlue tried to acquire Spirit, they'd probably still face another Department of Justice fight.
In a joint statement, JetBlue and Spirit said they're evaluating their next steps as part of the legal process. So that means, will they appeal or won't they appeal?
Exactly. Right. They're thinking about it.
And what do you think about their chances on appeal?
You know, I think their chances aren't great. And it's because this was really a question of interpreting the evidence, the testimony by the experts and the documents, and ultimately deciding, you know, which arguments were stronger and more valid than others. And that kind of a decision is given deference by an appellate panel because it needs to be shown that it was clearly erroneous. And that's hard to meet. So I do think an appeal would probably be an uphill climb for the airlines. And time is a little bit tight, too, because it could take 5 to 6 months, let's say, from notice of appeal to decision. And they do have a merger end date of July 24th. So the timing's a little tight there, too.
And how much does JetBlue have to pay if the deal doesn't go through?
So they've agreed to pay $470 million. Part of that goes to shareholders, part of it goes to Spirit, and that's minus some prepayments that have already been made. I don't actually know how much has been made, but the whole grand total of prepayments plus post-failure fee is $470 million.
Not a drop in the bucket.
No, not at all.
Could this ruling spell trouble for JetBlue's rival, Alaska Airlines, and its acquisition of Hawaiian?
You know, I may be in the minority here, but I don't actually think it makes any difference, and I'll tell you why. Because I always thought that deal would probably get challenged by the DOJ. They just simply think that the airline industry is already too consolidated, and if they go in with that position, they may be more interested in trying to challenge this deal in court than allowing it to go through. So I've always thought that there was a chance of that. I think that deal's much easier to fix than this deal is, because really that's just a straightforward combination of two competitors that overlap for, I understand, a pretty small number of routes overall, and then they can divest those routes to other carriers, which is generally the way past airline mergers have been remediated in the past. And I think that if they divest a sufficient number of routes to the right buyers, it seems to me they have a very good chance of winning in court. With JetBlue and Spirit, you had this whole other problem of these routes where they didn't compete, where it was only Spirit flying the route, but it was now going to become JetBlue and the prices were going to go up. So they had a different problem than will exist with the Hawaii-Alaska combination.
This is the second time in less than a year that JetBlue has lost a federal antitrust challenge. Is it time to just give up?
I would have said it was time to give up before they entered the merger agreement with Spirit. I don't think it's really any big surprise that deal was challenged and that the DOJ won it in court. And I still wonder sometimes whether the whole reason for entering that agreement was just to stop Frontier and Spirit from merging. That's the very skeptical side of me, I guess.
Lawyers are supposed to be skeptical, so.
Exactly. I'm supposed to approach this skeptically. You know, I think it's pretty clear that they'd have a tough time buying up another airline. You know, at the very least, they would be challenged and have to fight it in court and try to win in court. I'll tell you that on the NEA, I was a little bit surprised. I sat through that trial, too, and I actually thought that the NEA would stay in place with some modifications to it. And so I was a little bit surprised that the judge abolished it altogether. And I actually think that there was a chance that he may have allowed for the NEA to stay in place, but without the revenue sharing that was part of it and without some capacity coordination that was part of it. So really, it was just a code-sharing agreement. But at the time the companies were ready to present that to the judge, JetBlue had backed out. The termination date had come and gone, and JetBlue had backed out, which was their right, because they thought it would help them to win this Spirit trial. And so the judge never entertained that possibility.
The Biden administration is doing very well with antitrust concerns in the airline industry, but what about other industries? Is it faring as well?
I would say, in my mind, they're doing better, I think, than many are giving them credit for. And the DOJ now, this is 3 wins in a row for the DOJ after the NEA case that you mentioned, and also successfully blocking Penguin Random House and Simon & Schuster from completing their deal. The FTC has had some very big losses that have been in the news, but they've also succeeded in achieving a lot of abandonments. And abandonments are also considered a success, because essentially it's done what they intend to do. It has stopped the consolidation that they don't think should go forward. So I think people aren't really giving the FTC enough credit for the abandonments of deals that they've achieved. And I would also say that the cases that they have brought have been very difficult cases to win in court. They have been novel theories. They challenged, Microsoft Activision was a vertical integration case. It's very hard to win a vertical integration case. And perhaps they haven't picked and chosen the cases to challenge quite as well as the Department of Justice has. But I think that now they're gaining some steam, and now they're kind of getting their legs under them, and I think it still remains to be seen what happens in the rest of this year. If the FTC actually does sue to challenge Kroger-Albertson's deal, what happens there, and with other deals that are pending right now as well.
Always a pleasure to have you on, Jen. That's Bloomberg Intelligence Senior Litigation Analyst Jennifer Rhee. And that's it for this edition of the Bloomberg Law Podcast. Remember, you can always get the latest legal news by subscribing and listening to the show on Apple Podcasts, Spotify, and at Bloomberg.com/podcast/law. I'm June Grasso, and this is Bloomberg.